Good afternoon to you, Mr. Satyam. I've seen first time.
Good afternoon, sir.
Good afternoon, Abhishek.
Good afternoon, sir.
Afternoon,
Good afternoon, sir.
Praveen. Afternoon.
Good afternoon, sir.
Afternoon. Yeah. Any doubt you have in the last few classes? Feel free to ask. Whatever doubt you have, you should ask. Okay. So whatever portion we complete, simultaneously you should study. You should do a reading. Therefore, we will take MCQ. By that time, you will know it's your inherent weakness. But still, okay, to continue, we have seen in the last class what is the penalties, both minor and major. What is the procedure for imposing minor penalty? Which cases major penalty procedure should be followed? I told you minor penalty proceeding is 16 and 17. 17 is common. Communication partners. 16 gives you the procedure for imposing minor penalty. From MCQ point of view, in the minor penalty, you should know whether inspection document is allowed or not. Yes, allowed. And the requesters are official. It can be allowed. And there is no question of any oral inquiry. He is not given the right to be heard in person. Suppose if he wants an oral inquiry, it is at the discretion of the disciplinarian, not the inquiry. The discipline. Now we are coming to major penalty procedures, which is relatively very cumbersome. But we will try to make it as simple as possible. I told you yesterday, there are 4 jurisprudence principles. No person can be condemned without hearing. One of the 4 principles. Every person is innocent until unless otherwise is proved. Every crime should be proved beyond doubt. If there is any doubt, the benefit of doubt should go to the accused. You can let off hundreds of criminals, but you should not punish an innocent. And third is, no person can be condemned without hearing. You should give any person, even you don't like a person. See, Mr. Abhishek is saying voice is not clear. What about the others? Is it clear? Please be frank.
Yes, sir. The audio is breaking.
It is
Yes, sir.
breaking. Okay.
To me also, sir, the voice is not coming that clearly, sir.
We will see. Yesterday, 2 minutes. Okay. So, what I was mentioning, the 4th principle is no person can sit on judgment on his own decision. If I have taken a decision, I cannot decide whether the decision is right or wrong. It should be the other person. That is the 4th principle of jurisprudence. Now, in the Rule 14 inquiry, we follow the 3rd principle. No person can be condemned without hearing. Why? It is in consequence of Article 311, which provides you 2 safeguards. Of it, one safeguard is no person can be dismissed, removed, or reduced in rank except after an inquiry in which he is informed of the charges and is Are you able to hear me now? Is it clear? Is it clear?
Yes, sir.
Earlier?
Yes, sir.
Yes, sir.
Huh? Is it clear?
Yes, sir.
Yes, sir.
Yes, sir.
Yes, yes, sir.
Okay. Abhishek, is it clear now? Where is Abhishek?
Yes, sir.
Is it
Sir.
clear?
Yes, yes.
Okay. So, the major penalty, that safeguard is fulfilled. First thing is, first stage of the major penalty procedure is, you should send him a proposal, intimation of proposed Rule 14 inquiry. Along with the proposal, you should send what is popularly called charge sheet. Charge sheet consists of 4 parts. One is article of charge. Second is statement of imputations of misconduct and misbehavior. Third is list of admission or list of confession made by the government servant. Fourth is list of witnesses and list of documents by whom and by which the charges are proposed to be sustained. All these 4 put together, it is called charge sheet. The charge sheet, yesterday I told you what is the difference between article of charge and statement of imputation misconduct and misbehavior. Article of charge is nothing but the substance of statement of imputations of misconduct and misbehavior. It is a narrative statement, giving you the full background of the misconduct. Whereas, article of charge is nothing but a substance. It will have only 1.5 line saying, suppose a government servant involved in a misappropriation, Mr. A working as cashier or in any post has allegedly misused or allegedly, remember it is not proved, so allegedly misappropriated certain money, thereby violating Rule 311, that is lack of integrity, of CCS Conduct Rules 1964. So article of charge should indicate which rule has been violated specifically. On the other hand, how this misconduct has happened, that is given in the statement of imputation misconduct misbehavior. Complete detail. Everything is detailed in detail given. Okay. This charge sheet is received by the government. Remember, he is to reply to this charge sheet, what is popularly known as written statement of defense, WSD. That WSD or written statement of defense or the explanation should be sent by him. The time limit is 15 days. Remember, the 15 days can be extendable another 15 days. This can further be extended another 15 days for the reasons to be recorded in writing. So what is the total period? 45 days. This timeline is important. 15 plus 15 plus 15. First 15, legitimate. Second and third 15, the disciplinary authority has to make a report, has to make a indication in the file what are the circumstances which necessitated for extension of time. 15 plus 15 plus 15. 45 days is the maximum. Remember. Now the government servant will reply. He will send the written statement of defense. He will specifically say, that, let us say there are 4 charges. Unauthorized absence from duty, misbehavior with the section officer, shortage of money. These 3 charges are there. These 3 articles of charge has been given. What he has to say, he should say whether he admit the charges or not. Understand? Kindly understand? He should say whether he admits the charges or not. He may admit 1 charge, he may deny 2 charges. He may admit 2 charges, deny 1 charge. He may admit all the 3 charges. But if he admits, that admission should be without any qualification. Without any no qualification, but or still, that should not be there. Total admission should be there. No subjective, no condition, nothing is there. So if he admits all the charges and send the reply, no further action. So the disciplinary authority need not conduct any inquiry if the charged official admits all the charges. Okay. If he admits 1 charge, 2 charges denies, then remember, the disciplinary authority has to conduct the inquiry in respect of the charges which have not been admitted. Suppose he admitted 2 charges, denied 1 charge, for that charge he has to conduct inquiry. Now, let us say he has sent the defense in which he has admitted all the charges, or he had denied all the charges. For example, he had denied all the charges. Now, remember, very important, it has been received. Now, you have to conduct the inquiry. What is the constitutional mandate? Article 311, I told you, no person can be dismissed or removed or reduced in rank except after an inquiry in which he is informed of the charges and is given a reasonable opportunity to be heard in person. That person is the inquiry. Now, disciplinary authority has 2 options. One option is he can himself hold the inquiry. He need not appoint an inquiry authority. Another option is he can appoint an inquiry authority. There are 2 options. But remember, justice should not only be done, but appear to be done. Image is more important than the reality. Howsoever you are very docile, etc., etc. What is the image? What is that decides the reputation? The reputation is decided by your image. What is inside? That is only angels and God will know. What exactly you are, that the world will know, the persons will know, depending upon your reputation. Character is different. Moraji Desai is a man of character. Jawaharlal Nehru and other people may not be the man of character, but reputation is what the people see. Character is what the God and the angels see. So, the justice should not only be done, appear to be done. That is more important. So, normally, the disciplinary authority, despite having the option, discretion to hold the inquiry himself, what he is expected to do is, he will appoint the inquiry authority, okay, for holding the inquiry into the charges which have not been admitted. Remember, which have not been admitted. Okay, he had appointed the inquiry authority. Now, remember, when he had appointed the inquiry authority, who will take his brief? He will not be there. Who will take the interest of what is known as this fellow? There's a disciplinary. Okay. So, what he will appoint the inquiry authority? Then in that case, who will take care of the interest of the disciplinary authority? So, he will appoint who is known as presenting officer. Remember, presenting officer. The presenting officer is to present the case on behalf of the disciplinary authority. Very important point. What is the role of the presenting officer? He will present the case on behalf of the disciplinary authority. To whom? The inquiry authority. Now remember, the government servant, inquiry is to be started. Disciplinary authority has authorized the presenting officer. So equal opportunity should be given to the government servant also. So the government servant can take the assistance of, remember, very important from MCQ point of view, he can take the assistance of any serving government servant or retired government servant, even suspended government servant. Remember, any of the person he can take. The government servant can take the assistance of any serving government servant or retired government servant or even suspended official, either from the headquarters or from the place of duty or where the inquiry is to be conducted, place of inquiry. These three places. Suppose he wants to take the assistance of a person who is working outside, he can take with the permission of the disciplinary authority. So remember, with the permission of the inquiry authority, he can take the assistance of any other government servant who is not available at the place of inquiry or his headquarters. Okay. Now remember, most important, if he is a serving employee, he should not be having the cases more than 3 MCQ. Serving employee, what is the limit? 3 cases. If he is a retired official, in that case, he should not be more than 70 years, number 1. He should have retired from central government service, number 2. He should not have been associated with the case as an investigating officer or as a witness, number 3. He should not be having more than 7 cases. Remember, 3 for the serving officer, 7 for the retired government. He can take the assistance of the retired, including suspended official or serving official, either in the place of duty or headquarters or any other place which is authorized by the inquiry. Okay, suppose I am a place under suspension. Place of inquiry is Delhi. My headquarters is, let us say, Meerut, either Meerut or Delhi. Now I want to take the assistance of a person from Karnal. In that case, remember, you need not take the permission of anybody. Myself, I do not need to take any permission. But the person whom you are nominating, he should take permission for leaving the headquarters. Number 1. If the person, the third person that is other than the headquarters, if you are not allowed, suppose the inquiry authority says, no, I have given you choice, either you can take from the place of duty or headquarters. I will not allow the place outside your headquarters, means you have a right of appeal. Actually, this will not come under the appeal. You can represent to disciplinary authority. Remember, who will allow the defense counsel? Inquiry authority. That inquiry authority is not allowing you to take the services of a person other than the place of inquiry, other than the headquarters. In that case, in case inquiry authority refuses to allow you, then you have a right to appeal. You cannot call it as an appeal. You can represent to the, what is known as, to the disciplinary authority. Why this cannot be called as appeal? Appeal is not allowed for interlocutory natures. Appeal is not allowed for interlocutory nature. Problem. So you have to, that is the point you should remember. Now remember, you have appointed inquiry authority, you have appointed presenting officer, you have allowed the defense counsel. Now, the inquiry authority will forward all the documents. What is the documents? Statement of defense, the charge sheet, statement of important misconduct, misbehavior, article of charge, list of witnesses, list of documents, list of admission, list of confession, and the written statement of defense received from the government servant. All these things will be forwarded to the inquiry authority. Inquiry authority will be forwarded. Now remember, inquiry authority will start the inquiry within 30 days. Remember, 30 days. Within 30 days, on the appointed day, the person, the accused government servant will come. He will, once, suppose let us say, I give another opportunity, that is another possibility. The accused government servant does not reply. Does not reply. He refuses at the original stage. First stage itself, I am not replying. In that case, remember, you should take this as denied. So you should appoint the inquiry authority, etc. You should hold the inquiry. Now the inquiry is started. The inquiry authority, first thing, he will send same thing to the accused government servant, ask him to present within 1 month. Now let us say he is not coming. The accused government servant, in spite of the fact that the inquiry authority has forwarded again the notice, the accused government servant does not come for the inquiry. Or let us say he comes, he does not reply. Or he refuses to reply. Or he refuses to comply with any of the provisions of CCCC rules. In that case, remember, simply for that reason, the inquiry authority should not continue this. He should decide the case ex parte. This is called ex parte, one-sided. It is on your own. Suppose in a case, if you are not going on the summoned date, the court will decide on its own. You have been given the opportunity, you did not avail the opportunity, the court will decide. Similarly, here, the inquiry authority will decide the case. One option. Second, let us say he comes. The inquiry authority is asking, these are all the charges against you. What is your view? What is your defense? Suppose if he admits all the charges, before inquiry authority, if he admits all the charges, finished. There is no need for any inquiry. So he will take the signature and the case is closed. And the case will be sent to disciplinary authority for taking action under Rule 15. Action on the inquiry report. Okay. Now, he denies all the charges. So, the first point is the presenting officer will be asked to present his witnesses, his documents. Each witness, there are 3 stages. Remember, there are 3 stages. What are the stages? Examination in chief, cross-examination, re-examination. Suppose I am the witness. I will narrate the complete background. Yes, I was the SO. I was in charge of this DDO, I mean, cash section. Mr. So-and-so was the assistant. He was in charge of the cash and the DDO came at that time. This is my statement. This is called the examination in chief. Now, against me, I will be cross-examined by the defense counsel because I'm a prosecution witness. Defense counsel will cross-examine. Once he cross-examines, remember, on the points of cross-examination, the other person will re-examine. So you should know the 3 stages. What are the 3 stages? Examination in chief, I myself narrating. Secondly, cross-examination, opposite party cross-examination. And my party, my presenting officer, re-examining. So that is 3 stages are there for witnesses: examination in chief, cross-examination, and re-examination. So this will be done by all the people. For all witnesses, all documents, it will be produced. Now the role of the presenting officer. So he will give the examination in chief, cross-examination, and re-examination. So this is over. Once it is over, there may be occasion. Suppose some documents may be missing. So the inquiry authority will give the opportunity to presenting officer to fill the gap. If there is a gap in the evidence, the inquiry authority will give the opportunity to the presenting officer to produce any other evidence that is possible. Remember, if you provide such opportunity, remember the same opportunity should be given to the accused government servant also. Now, the presenting officer role is over. Now remember, now it is the turn of accused government servant. The accused government servant will produce his witnesses, his documents. Now the same examination in chief, cross-examination and re-examination will be done by the defense counsel and the presenting officer as far as the witnesses of the defense is concerned. Now remember, two things are over now. After the examination, re-examination, cross-examination and re-examination is done by both the parties, then remember, there is a stage called written brief. Written brief is nothing but a summary of the arguments. Summary of the arguments given by both the parties. Summary of the arguments given by both the parties. So that summary, the written brief, first it should be provided by the presenting officer. A copy of the written brief will be given to the government servant, and the government servant will give his written brief to the inquiry authority. Remember, very carefully, listen to me. This will again, it will be given to the first written brief will be given by the presiding officer to the accused government servant. Accused government servant will give his written brief to the government servant. That is what is called the defense counsel will give to the presenting officer. Both are exchanged. After that, remember, the inquiry authority can put such questions. Because, very important thing is, suppose most of the government servants do not know the procedure. So it is the interest of the justice, the inquiry authority will put such questions citing the evidences which are against the government servant, which are against the government.
The video is fast.
Due to network problem. I think some problem is there in the network because of the rain. It's raining here.
I am able to hear you, sir, properly.
You are able to hear me?
Yes, sir. All
Okay.
throughout the
Yes, sir.
Because of that. The screen says there is the video is passed. You are passed and I do not know. If you are
But your
able
video
to
was
hear
not
it,
passed, sir. Yes, sir.
okay.
Even the
Then
video.
you are able to understand. You are able to hear.
Yes,
Yes,
sir.
sir.
Okay.
Yes.
Okay. So remember, again I repeat, the first role is presenting officer. Presenting officer, he will produce his witnesses. His witnesses will be examination in chief, cross-examine and re-examine. Then the role of government servant. He will produce his witnesses. 3 stages. His witnesses will be examination in chief, cross-examination and re-examination. After this stage is over, both the people will have to prepare the written brief. Written brief is nothing but a summary of the total step-by-step action taken during the inquiry. And every day there is a daily order. Daily order is the most authentic document as far as inquiry is concerned. Why? Because the daily order is signed by all the officers present. Both the defense counsel, both the witnesses, all the people should sign what is known as daily order. The daily order is the most authentic. So the written brief will be given first by the presenting officer, The written brief for the presenting officer will be handed over to the defense counsel, otherwise called the accused government servant. Based on this, the accused government servant prefer a written brief. Now, remember, the most important duty of the inquiry authority is he will put such questions and such clarification to the accused government servant to elicit the truth. What exactly happened? Because, they may be scared, they may be afraid. So, the inquiry authority's main aim is to get the truth out of the defense counsel, the accused government servant. So, he will put such questions so that the accused government servant comes with the full narration of the truth. Once this is over, remember, all the inquiry is over now. Now, the inquiry authority will prepare a report of inquiry, very important stage. This report of inquiry will say what are the charges, what are the findings. The inquiry authority will not say whether the charges have been correct, what penalty should be issued. No, it is none of his business. If there are 3 charges, the inquiry authority will say whether the charges is proved or not. That's all. Each charge, whether it is proved, if not proved, why it is not proved. Proved, how it is proved. Some cases it may be partly proved, partly not proved. Justified. You are not expected to give your opinion. You have among the quantum of penalty. You have to simply say whether the charges are proved or not. Then he will prepare the inquiry report. Now, remember, Rule 14 is over at this stage. He will send this report to the disciplinary authority. Kindly follow, listen to me carefully. Inquiry is over. Now this is sent to the inquiry authority. The inquiry authority will prepare an inquiry report, and that report will be sent to the disciplinary authority. Rule 15. 14 is over. Rule 15. Listen to me carefully. Now, the disciplinary authority has various options. Option number 1. He may remit the case for further inquiry. For the reasons to be recorded in writing, he can say, I am not satisfied with the inquiry, please inquire again. With such orders as he deems fit, he can send the inquiry back to anybody, not necessarily the inquiry authority. Here, the same inquiry authority. He can appoint another inquiry authority, send it for, remit for further inquiry. This is number 1. Number 2, after having taken into account all the evidences, all the witnesses, what he can do, he can impose minor penalty. Remember, major penalty procedure followed. Now he is imposing minor penalty. Now, is it necessary Rule 16 should be followed? No, not necessary at all. Why? Already you have followed the procedure meant for major penalty. There is no need to follow what is known as the minor penalty procedure. So, he will impose the penalty, minor penalty. But remember, once you are before imposing, there is a constitutional mandate. What is that? You should send the copy of the inquiry report. To the government servant. Whether the inquiry report is favorable to the government servant or against the government servant, does not matter. You have to forward a copy of the inquiry report to the government servant. Government servant should respond within 15 days. Remember, again, timeline. Within 15 days. Okay, you have got the report. After having received the report, remember, suppose you are referring this after the inquiry report response has been received, you will send, suppose the fellow belongs to Group A or Group B, or if he has been appointed in consultation with what is known as UPSC, you will send this to the UPSC and take the advice of the UPSC. Once you have taken the advice of the UPSC, you will send this advice to the government servant for his comment, for his views, for his representation. He should send a reply to the UPSC advice within 15 days. Remember, 15 days in that inquiry report, UPSC advice, 15 days. The moment it has come, now remember, there is another authority, which is not a statutory authority as far as CCCC rules are concerned. There is another organization called Central Vigilance Commission. The Central Vigilance Commission, there are two stages. One is when a charge sheet is issued, you have to take the first stage advice of the CVC in all vigilance cases. In all cases where there is a vigilance angle, you have to take the advice of the CVC invariably. When you take the advice of the CVC, first stage advice, you have to send it along with the charge sheet. Now, second stage advice, you have to send separately to the government servant, take his representation within 15 days. Kindly remember now, he has got the report of the inquiry authority, he has got the report of the UPSC, he has got the report of the CVC advice. The second stage advice is not mandatory. Underline, it is not mandatory if UPSC has consulted. If there is a consultation with the UPSC, CVC advice not necessary. In cases where there is no UPSC advice is there, then CVC second stage advice is mandatory. Now the government servant has already sent his response with regard to the inquiry report, with regard to the UPSC advice, with regard to the CVC advice, and the disciplinary authority has all written statement, response, inquiry report, witnesses, evidences, everything is now. Now, keeping all these things, remember, he can impose minor penalty. There is no need to follow minor penalty procedure because he has already undertaken major penalty procedure. Very simple. Suppose if you have purchased a first class ticket in the train journey, if there is no space, there is no seat available in the first class, and TTR says you travel in the second class, I will give you a seat. If you very urgent, you can travel. You will not purchase another second class ticket because you are a bona fide passenger. You have got the first class ticket, so you will as well travel in the second class. Remember. So, similarly, if the major penalty procedure has already been followed, in that case, there is no need for minor penalty procedure. Straight away, you can issue minor penalty after consulting commission wherever necessary. We have already consulted. This is number one. So, what let us say, you have to impose what is known as major penalty. Yes, you already conducted major penalty procedure. You can impose any other penalty. Here, the very point is, there are two people. One is disciplinary authority and another is appointing authority. I told you in the first class, all disciplinary authorities are not appointing authorities, but all appointing authorities are disciplinary authorities. An authority who is competent to impose only censure, he is also a disciplinary authority. So, in such cases, remember, the disciplinary authority can, normally, let us say, a disciplinary authority has the powers to impose only minor penalty. Even though his competence is only to impose minor penalty, he can hold the inquiry for major penalty. Nothing prohibits. After Rule 14 inquiry, after getting the inquiry report, the disciplinary authority will forward this to the competent appointing authority for imposing major penalty. Kindly understand. Very important point. There are two people. One is disciplinary authority, who is competent to impose only minor penalty. But you want to impose major penalty. You can hold the inquiry. You can issue everything. You can send the charge sheet. All inquiry can be conducted. But after the inquiry is over, the inquiry authority will send it to the disciplinary authority. That disciplinary authority will send the case to the competent appointing authority for imposing major penalty. Very, very important point. What normally MCQ is possible in. So it is not necessary that the appointing authority is the person who is imposing major penalty. Only he has to conduct the inquiry. No, not at all. Even the authority who is competent to impose even censure, he can hold the inquiry. After inquiry, suppose let us say, I tell you another thing. Suppose let us say the charge sheet is issued, major penalty charge sheet is issued. Kindly listen to me carefully. Major penalty charge sheet is issued. You have received disciplinary authority. He is not competent. The disciplinary authority who issued the charge sheet, major penalty charge sheet, is competent to issue only minor penalty. You have got it. But the charge sheet is major. Authority is minor penalty authority. Now, why he has issued? After conducting the inquiry, I will send it to correct disciplinary authority who is competent to issue dismissal. Now, after receiving this, even though the original intention is to give him major penalty, the minor penalty can be imposed by the disciplinary authority. There is no need to send it to the major penalty. That is the competent authority. Very important. Again, I repeat. I am the disciplinary authority. Mr. Abhishek is the appointing authority. He has said that some miscreant he has committed a fraud. I am proceeding. I am a disciplinary authority. I can issue the major penalty charge sheet. I have issued it. My intention is to impose the major penalty. And I will transfer the case at the time of imposition to the appointing authority. That is my intention. I have issued the charge sheet. The fellow has sent. But at the time of sending, I see the difference. No, the major penalty is not necessary. I am imposing minor penalty. Yes, there is no need to consult the appointing authority. Remember, very important. There is no need to consult the appointing authority. So, the Rule 15 is over. Once the charge sheet has been issued and penalty has been imposed, in the file, it will be ordered. Remember, most important, once an order has been recorded in file, even successor cannot change it. Suppose let us say, you are the disciplinary authority. You are the appointing authority. You are imposed. You are in the file. You are written so and so should be dismissed from service. It is an order. Now you have been transferred. I take over. I read the case. No. This is dismissal is too severe. I want to change it to compulsory retirement. No, I cannot change. An order recorded in file is final. It cannot be changed even by the successor. It can be changed only by the appellate authority. That is a different issue. First point you should. Second point. Dismissal cannot be retrospectively. Very important. Dismissal is only from the date of issue of orders. It cannot be retrospective. Number 3. All disciplinary proceeding will end with the death of the official. All dead men are good men, irrespective of whatever sin he has committed, whatever the damage he has done to the society or family. The moment he dies, he is a good man. So all the disciplinary proceedings will end with the death of the government servant. Fourthly, remember, supposing let us say a government servant has been under suspension. He was dismissed from service. He was involved in another case. I have told you just now, with the death of the government servant, all disciplinary proceedings gone. Now the fellow after dismissal comes back. After death, he cannot come back, obviously. After suspension, after dismissal, he is coming back. The moment the dismissed government servant comes back, the disciplinary proceedings which you have closed will be revived. Very important point. Mr. A under suspension, dismissed from service. Simultaneously, there are 2 disciplinary cases. When he has been dismissed, naturally, those disciplinary cases gone. He already dismissed. Now, let us say he made an appeal. He has been reinstated, come back to service. The moment he enters, that those cases which have been closed will be revived. Very important. You should keep in mind. And another, most of yesterday I told you that we have a vicarious pressure to harassing people. So there are officers who will just issue a charge and keep quiet. So it is a mental agony for the fellow, and you can always like a blackmail. So the rule is, without informing the government servant, you cannot close the case. Every case has to be closed only after informing. And the investigation, any case, Rule 14 inquiry should be completed within 6 months. If it is more than 6 months, it has to be reported to the next higher authority. It can be extended for another 6 months for the reason to be recorded in writing, which has to be reported to the higher authority. But remember, most importantly, there is no maximum time limit. So, there is no maximum time limit. This is the procedure for imposing major penalty. So, we have seen 14, Rule 14, Rule 15, Rule 16, Rule 17. 17 is a communication avoidance. I have told you, once an order has been recorded in file, that is final. It cannot be changed. Under no circumstances it can be changed. It can be by the successor. That is most important. Now we are coming to Rule 18. Rule 18 is common proceedings. What is common? First thing you should remember is common proceeding does not mean suppose you and I fight, you can start a common proceeding. No. First thing is mutual altercation. Common proceedings are not permitted. First thing. Secondly, if there is a mass scandal, there is a medical reimbursement, fabrication of TA, there are group of people issued a false TA. In such cases, common proceedings can be followed. Rule 18. What is a common proceeding? Very simple. It can be a Group D, Group B, Group A, Group C, 4 or 5, 3 or 4 category, any number of staff can be involved. Point you should remember is the authority who is competent to impose the penalty or dismissal on all of them. Very important. If a class 4 is involved, a class 3 is involved, a Group B officer is involved, Group A officer is involved, any number of cadre, you should remember the authority who is competent to impose the penalty of dismissal on all of them. He will function as the disciplinary authority. So, intention is penalty of dismissal should be imposed on all of them. Who is competent? He will function as disciplinary authority. The order will indicate who will function as disciplinary authority, what is his competence, whether Rule 14, Rule 15 procedure will be followed or Rule 16 procedure will be followed. This is what is known as Rule 18, common procedures. Now we are coming to Rule 19. Rule 19 is special procedure. What is special procedure? I told you, Article 311, when we discussed, I told you the 2 procedural safeguards. One is no government servant can be dismissed or removed by any authority who is subordinate to the appointing authority, which cannot be dispensed with under any circumstance. Second safeguard, no government servant shall be dismissed or removed or reduced in rank except after an inquiry in which he is informed of the charges and is given a reasonable opportunity of being heard in person. This is the second safeguard. I told you the second safeguard can be dispensed with, can be waived in 3 circumstances. What are the 3 circumstances? Criminal conviction, inexpediency, and impracticability. What is criminal conviction? Where a government servant has been dismissed, removed on the ground of conduct which has led to his conviction on a criminal charge. Number 1. Where the President of India is satisfied that in the interest of security of state, it is not expedient to hold an inquiry. Where the disciplinary authority is satisfied that for the reason to be recorded in writing that it is not reasonably practicable to hold an inquiry. So these 3 cases, there is no need for any inquiry. The same ipso facto given in the Rule 19. Very simple. Where a government servant has been removed or dismissed on the ground of conduct which has led to his conviction on a criminal charge, no inquiry is needed. So what is the first line? Notwithstanding anything said in Article Rule 14, 15, 16, no 17. 17 is communication of order. So notwithstanding the provisions of Rule 14, Rule 15, Rule 16, in the following cases, no procedure need be followed. What are the following cases? Where the government servant is dismissed or removed on the ground of conduct which has led to his conviction on a criminal charge, no inquiry. Number 2, where the President of India is satisfied that in the interest of security of state, it is not expedient, desirable to hold an inquiry, no inquiry. Third, where the disciplinary authority is satisfied for the reasons to be recorded in writing that it is not reasonably practicable to hold an inquiry, no inquiry. These 3 cases covered under Rule 19. Nevertheless, first case, where a government servant has been dismissed or removed on the ground of conduct which has led to his conviction on a criminal charge, you have to undertake a skeleton inquiry. What is skeleton inquiry? You should call for his explanation. It is understood. It has been brought out that you have been convicted by the court. What is your explanation? Why? Understand, rule is nothing but the strong common sense. Why? Because there may be occasions where you have been convicted for a offense not connected to the official work. Not connected to the official work. So for that you will dismiss him. That's not correct. For instance, you fought with a neighbor. He have made a complaint. And you were inadvertently, you misbehaved in the court. The court convicts you till the rising of the court, you are convicted. Does it mean you are unfit for the employment? No. Mere conviction will not entail you unsuitability for the government service. So for which offense you have been convicted? Is it motor vehicle violation? Is it contempt of court? Or is it rash driving? Or is it dishonesty? Lack of integrity? If that offense has a connection with the government, connection with your work, then only you can be dismissed. Otherwise, you cannot be dismissed. So remember, to understand that reason, you will issue him a show cause notice, get the information. The rest of the 2 cases, conviction can be ordered. So remember, this is Rule 19. So remember again, recapitulate 14, 15, 16, yesterday we have seen 17, 18, 19. Now we are coming to 20 and 21. Action against a deputationist. Deputation. Suppose you are deputed for your ex-cadet post, or you have been deputed for another department, state government, or PSU, anywhere. What is the procedure under CCSE? This is dealt with in Rule 20 and 21. Very, very simple. Very simple. Rule, if you see, it will be very complicated. I will make it as simple as possible. Number 1. Remember, suppose your services are taken by other department. The other department is called borrowing authority. Your department is called lending authority. So we will not use other department, this department. We will use borrowing authority and lending authority. Your services are lent to the borrowing authority. The borrowing authority borrows the services from the lending authority. So, lending authority and borrowing. Suppose you are on deputation to the borrowing authority, you are working there. Now, if you have indulged in any mischief, misconduct, remember, as far as suspension is concerned, the borrowing authority has full powers of disciplinary authority. borrowing authority has full powers of disciplinary authority. They can suspend, subject to one condition. What is the condition? The moment the person was suspended, the borrowing authority should intimate the lending authority the circumstances under which the suspension was resorted to. Very simple. He has to intimate. Otherwise, he enjoys full powers of the disciplinary authority. Okay? Suspension. Second, you are working in the borrowing department. You have done some mischief or misconduct. The borrowing authority, remember, can issue charge sheet. All Rule 14 procedure can be followed. They can issue charge sheet for imposition of major penalty also. Remember, be clear in your mind. Even though the borrowing authority has borrowed your services, they are at the liberty to issue you a major penalty proceedings. Rule 14, issue the charge sheet, list of witness, conduct the inquiry, appoint the inquiry authority, appoint the presiding officer, defense counsel, everything the borrowing authority can do. Now, let us say, they issued a minor penalty procedure. They issued a charge sheet to you for minor penalty. You have sent the written statement to you. Now remember, the borrowing authority can impose you any of the minor penalties. Absolute freedom. But one condition is there. Before imposing the penalty, they should consult the lending authority. If the lending authority disagrees, and remember, he should be replaced. And after child mischievous, send back. You have adopted him temporarily. You thought he is okay. But he has got some relation with the old department. He has manipulated. So the old department says, no, you cannot impose minor penalty. We are not agreeable to minor penalty. Send back. Why to have the headache? Number one. Number two, you got the inquiry conducted, witnesses, evidence, all the written brief, everything is there. As borrowing authority, you think he deserves to be given major penalty. He deserves to be given major penalty. Remember, the moment you decide that he should be given major penalty, send him out. Replace his service. Replacement of services is will not amount a penalty. I already told you. So send him back along with the case. Along with all the details, you send him back. So this is what. These are all the two, 20 and 21. I think there should be, again, I repeat. Very simple, borrowing authority, lending authority. Borrowing authority has full powers as that of disciplinary authority in case of suspension. The only thing is, he has to intimate the lending authority the circumstances of suspension. Number one. As far as minor penalty is concerned, they can issue minor penalty. Absolute freedom. Subject to the condition that they should agree, the lending authority should agree. If there is a difference of opinion, forget sending back. Suppose if you want to impose a major penalty, you have no powers. You can conduct the inquiry. Absolute freedom. You can hold the inquiry, Rule 14, charge sheet, article of charge. Everything you can do. But imposition of penalty, not possible. Send him along with the file to the lending authority. Let them decide. This is Rule 20 and 21. Now we are coming to appeal. Very important. 22, 23, 24, 25, 26, 27, 28. 6 rules are there. What is appeal? In which cases appeal lies? In which cases appeal does not lie? What are the conditions for preferring appeal? While deciding the appeal, what points you will take into consideration? These are all the points covered under these. What is appeal? Appeal is nothing but a statutory representation against any penalty or any disadvantageous decision relating to the conditions of service. This is appeal. Now, In which cases appeal lies? In which cases appeal does not lie? First, we will see in which cases appeal does not lie. Then we will go which cases appeal lies. Appeal does not lie. Number one, an order made by the President of India. Obviously, you cannot go to UNO. Any order made by the President is final. So no appeal lies against an order made by the President. Number two, any order of interlocutory nature or of the nature of stipulate or final decision of the disciplinary proceedings other than an order of suspension. What is this? Very simple. Any order of interlocutory nature. Interlocutory nature is interim. It is not decision. I will give an example. Let us say now assistant and grade C stenographer are the same. Let us say there is a proposal. Any graduate assistant, they can be after 4 years, they can be inducted to what is known as Group B automatically. They will switch over to Group O, what is the level 10 or level 11 straight away, Danix. This is a proposal. Immediately the grade C stenographers, their association comes up. We are also recruited in the same way. We may not be graduate, but those who are acquired graduation, they can be considered. So they make a representation. This is interlocutory. Why interlocutory? It is a child in embryo. How can you name it? It is only a temporary. It is only at this inception stage. No decision has been taken. So interlocutory. Another example. Let us say a divorce proceeding. In the divorce proceeding, divorce has not been given. In the meanwhile, custody of child comes. The court says the child, because it is less than 1 year, it will be with the mother. So it is without prejudice to the final decision. It's an interlocutory nature. Another, suppose as a government servant, you are asking the assistant, accused government servant, wants to take the services of a person who is not in the headquarters or who is not in the place of duty as defense assistant. Inquiry authority says no. Now he makes, why he says no? He wants to make an appeal. No, appeal is not possible. It is interlocutory nature. Temporary. That is called interlocutory. Now read it. An order made by the President of India, an order of interlocutory nature, or the nature of stepinate and interlocutory same, or the nature of stepinate, or final disposal of disciplinary proceeding. Final disposal. So when the moment a disciplinary proceeding is issued to you, Rule 14 charge sheet is it. Does it mean you will make an appeal? No. It is only pending. You are not imposed any penalty other than an order of suspension. Suspension, appeal is permitted. Other than an order of suspension. And any order made by the inquiry authority during the course of inquiry. During the course of inquiry, just now told you, the inquiry authority says next Friday, 13th is the hearing. No, sir, my horoscope says 13 is very bad for me. Friday, there was always problem in my house. Put it Saturday. No. An order made by the inquiry authority cannot be appealed against. Very simple. So, where the appeal does not lie. Where the appeal lies, number one. Any order of suspension or deemed suspension. Any order of penalty or enhanced penalty. Suspension or deemed suspension. Any order of penalty or enhanced penalty. Any order which is treating as the pay and allowances during the period of suspension. Any order which denying the pension, which withhold the pension, which withdraw the pension, any order relating to the pay and allowances of the government servant, any order which is relating to the conditions of service of the government servant, any order how to treat the period of suspension from the date of suspension to the date of retirement, date of reinstatement, how do you treat? Whether that period will be treated as a qualifying service or not, all these things. In addition, there is supersession of promotion. Yes, that is also. All these things are called suspension. That is what is known as appeal lies. Now, what are the conditions? Remember, very important condition. The appeal should be couched in a respectful language. Appeal should be addressed to the appellate authority with a copy to the disciplinary authority. No joint appeal is allowed. Even in the common proceedings, no joint appeal. Joint appeal is amounting to subversive of discipline. Disciplinary action can be taken for preferring a joint appeal. Appeal should be given within 45 days from the date of receipt of the orders appealed against. It is always addressed to the appellate authority with a copy to the disciplinary authority. Disciplinary authority has no powers to withhold an order, withhold an appeal. He has to send along with his parawise comments to the appellate authority within 45 days. Remember, these are all the conditions. Most important condition, 45 days. No joint appeal. Couch it in respectful language. Address to the appellate authority. Copy to the disciplinary authority. Disciplinary authority has no powers to withhold. He has to send it within 45 days, along with his parawise. And remember, the powers of 45 days can be condoned by the appellate authority. Once an appeal has been preferred, it cannot be withdrawn. Very, very important. Once an appeal has been preferred, it cannot be withdrawn. Why? Very simple. The appellate authority has the powers not only to reduce the penalty, he has the power to enhance the penalty also. It is not necessary in appeal only the penalty should be reduced. No, not necessary. Penalty can be enhanced. So, the appellate authority has the discretion to increase the penalty. So, the appeal, once forwarded, once submitted, cannot be withdrawn. Of course, if the appellate authority agrees, yes, it can be withdrawn. Now, what are the points you will consider while deciding the appeal? While deciding the appeal, what points you will consider? Very, very important. Kindly listen to me carefully. What points an appellate authority will consider? Very simple. You divide all these representation, appeals, etc. into 3 categories. Number 1, suspension. Number 2, penalty. Number 3, others. Others, I told you, subsistence allowance, treatment of period of suspension, etc., etc. Denial of pension, withholding a pension, withdrawing the pension, conditions of service, etc. I told you. Now, so you give me 3 broad categories. One is suspension, another penalty, third is other categories, miscellaneous. First we come to suspension. I have already told you what is Rule 10. Rule 10, what are the statutory circumstances where the disciplinary proceedings contemplated or pending, where the activities of the government servant are judicial to the interest of security of state, where the in respect of any criminal offense, where the case is inquiry or investigation or trial, these 3 statutory circumstances. I have already told. I have also given you CVC guidelines, where the suspension is desirable, where the suspension is appropriate. 2 categories I have given separate. So you have got the guidelines, you have got the suspension. Compare it and decide whether suspension is justified or not. Accordingly, revoke or uphold. Very simple. Statutory circumstances plus CBC guidelines, compare this with the order of suspension, find out whether the suspension is warranted or not warranted. Accordingly, revoke or uphold. Very simple. Penalty. Kindly follow, listen to me carefully. Very, very important. Penalty or enhanced penalty? Penalty, how many types are there? 2 types. One is major and the other is minor. That is a minor penalty. You are looking into the minor penalty. Now, you find the disciplinary authority has been very, very light. Very serious case, he has not given adequate seriousness. He, remember, minor penalty, he has given very light punishment. It is a serious. Now, as appellate authority, you think, no, it's very bad. I want to impose major penalty on a person on whom only minor penalty has been imposed. Now, remember, if you intend to give him major penalty, you have to conduct the inquiry. Why? Because you are given minor penalty after following minor penalty proceedings. You are not held the Rule 14 inquiry. In that case, how can you impose major penalty? So, you can impose major penalty only after following the Rule 14, Rule 15 inquiry. So, this appellate authority will become the disciplinary authority. He has to conduct the inquiry. After getting the inquiry report, he will issue the major penalty. Very, very important. So, remember. Now, second, he has been given minor penalty. Minor penalty procedure as in Rule 16 has been sincerely followed. Now, Rule 16 he has given censure. You are the appellate authority. He said, what is this? He has misappropriate money. This fellow has given only censure. I want to give him reduction in, what is known as withholding of increment. I want to give him withholding of increment against a person who has been awarded only censure. In the grade, it is fourth. So what he does is, okay, remember, you have given him only censure. Appellate authority wants to raise this to withholding of promotion, which is the fourth in the cadre. In that case, remember, no person can be condemned without hearing. So you are raising that, even though it is both are in the minor, one is increased. So you have to give you a show cause. It is proposed to impose withholding of increment against your present punishment of censure. Give him an opportunity to give his representation. After representation, you can raise. So minor to minor, okay. If it is enhanced, you have to give your opportunity. So what you want to reduce it? Absolutely no. He will be very happy, you will be very happy. Okay. Suppose major, you have given him reduction in stage. Now you want to dismiss him. Major penalty proceedings are already conducted. So there is no need to follow the procedure. Already you are done. But you are increasing the penalty. So give him a show cause. Why? No person can be condemned without hearing. You are giving him the punitive. So that punitive thing, you have to give him notice. So give him a notice. After consulting commission wherever necessary. Very, very important. After consulting commission wherever necessary. Most important, another most important is, remember, the appellate authority should be, the orders should be both the disciplinary authority and appellate authority. Orders should be speaking orders. What is speaking order? Speaking order means the order itself should show what are the arguments. What is the facts of the case? What is the argument of the government servant? What is the argument of the defense counsel? What is the argument of the disciplinary authority? What is your argument? All the arguments should be couched in the letter. That is called speaking order. Without speaking order, just I have considered the appeal, it is rejected. No, it should be a speaking order. So remember, this is appeal. Very, very important. So, Rule 22, 23, 24, 25, 26, 27. Now we are coming to 29. Revision. Previously, revision and review was in the same rule, 29. Now they have bifurcated. 29 is revision, 29A is review. Who are all the revising authorities? What is the difference between revision and review? This you should know. Who are all the revising authorities? Number one, President of India, CAG, member personnel of Department of Posts, member services of Department of Telecom, head of department who are directly under the control of the government, appellate authority within 6 months from the date of orders appealed against, or any other authority who are specially empowered in the behalf within such time limit as may be prescribed in the said order, may at any time, either suo motu on their own or otherwise, call for the records of any inquiry, and revise the orders. They can revise the order. They can impose penalty where no penalty has been imposed. They can enhance the penalty. They can reduce the penalty. They can remit the case for further inquiry. That they can set aside the penalty. All powers are there. Again, I repeat, very important. Who are all the revising authorities? Number one, President of India. Number two, CAG. Number three, member postal services. Member personnel of Department of Post. Member services of Department of Telecom. Appellate authority within 6 months. Or head of department who are directed at the central government. Or any other authority who is specially empowered to be by general or special order made by the President of India within such time limit as may be prescribed the said order, may at any time call for the records of any inquiry and impose any penalty where no penalty has been imposed. Remit the case for further inquiry, enhance the penalty, reduce the penalty, set aside the penalty. The procedure, time limit, all these things are same as that of the appeal. Remember, what is the procedure to be followed? I already told you in the appeal. What points should be taken into consideration? I have already told in the appeal. How it should be dealt with? Already told. Subject to one condition. UPSC consultation automatically, because that is applicable for appeal also. The same procedure of appeal should be followed for revision also for other material. In addition, two conditions are there. Number one condition is the appellate authority, that is the revising authority, can examine the orders if the appellate authority happen to be the CAG or member personnel, member services, appellate authority. All these people should be subordinate to the appellate authority. Suppose let us say, if it is the President of India, appellate authority himself will also be the President of India. So, the appellate authority should be subordinate to the revising authority. Then only you can examine. Very important. Secondly, if the person has already preferred an appeal, you should wait for the disposal of appeal. Suppose he has not submitted an appeal, the period of appeal should be over. You should wait for the 45 days. Then only you can entertain the revision petition. These are all the conditions for revision. Remember, again I repeat, we have seen Rule 14, 15, 16, 17, 18, 19, 20, 21, 22 to 28, 29. 29A. Review. Very simple rule. Cannot forget this. Very important. In Constitution, Supreme Court 137. Same applies here also. Review powers are vested only with the President of India. Very simple. No other authority has the powers of review. The powers of review are not available to any other authority except President of India. So President of India on his own or otherwise at any time can call for the records of any inquiry and examine and impose penalty where no penalty has been imposed, or reduce the penalty, or enhance the penalty, or set aside the penalty, or remit the case for further inquiry. The procedure and the points for consideration, etc., are same as appeal, subject to two conditions. The President of India can entertain a review petition only under two conditions. What are the two conditions? Any new evidence which has not been produced at the time of trial, any new evidence which has not been produced at the time of original trial or original disciplinary proceeding is brought out to the notice of the President now. Number one. Number two, where there is a that particular evidence which has been brought out by the accused government servant has the capability of changing the dimension of the case. Remember, it should be a new evidence which was not produced at the time of original disciplinary proceeding, number one. Number two, that new evidence should have the capacity to change the dimension of the case. In that case, if these two conditions are satisfied, only President, underline, only President is competent to accept any review petition under Rule 29A. This is what is known as CCA rules complete. Remember. So we have completed CCA rules, and if there is any doubt, you tell me. Then we will switch over to Government of India decision. Tell me, are you able to hear me? Yoshna? Abhishek?
Yes, sir. Yes, sir. Yes, sir. We can hear you.
Yes, sir.
Huh?
Yes, sir. Yes, sir.
Certain way, clear. Tell me, Yoshna, Satyam.
Yes, sir.
Oh,
As of
okay.
now, no doubt, sir. As of now.
No doubt. Very good. So, now we are coming to some Government of India decisions. Before that, let us see some MCQs. Tell me. What do you mean? Some MCQ. Ex parte. An inquiry may be held ex parte if the presenting officer fails to appear before the inquiry authority. If the charged official fails to furnish his written statement of defense before the inquiry authority. If the charged official fails to appear in person before the inquiry authority. If the defense counsel fails to appear before the inquiry authority. Tell me.
2. A and B.
Huh? Yes?
First, sir, B
Sir,
and
B and
C.
B and
What?
C.
Huh? A.
B and C.
A and
Sir,
B.
first B and C, first option.
B and C. B and C. No, tell me. Not just to put in the Satyam B and C. That is 1. B and C 1. Satyam. Then others. What about Abhishek? Abhishek, Josna, Satyam has said. Ravi also B and C. Josna, quick. Tell me, Josna. Yes. Abhishek 3. That is ABC. Josna. Okay, answer is B and C. See, very simple. If the presenting officer fails to appear before the inquiry authority, where is the question of ex parte? He is the interested party. It's wrong. If the charged official fails to furnish his written statement of defense before the inquiry authority, yes, it is an ex parte. If the charged official fails to appear in person before the inquiry authority, yes, correct, B and C. D. If the defense counsel fails to appear before the inquiry, it is a hell for the accused government. In what way we are concerned? It is not none of our business. So B and C is the answer. Next.
Two. A is correct.
Pardon?
2. A is correct.
Put me in the
A and C.
just
Third,
put me in
A
the
and C.
record. Tell me. Yes, Ravi, I'm not able to hear you properly. Yes, Abhishek, very good. Abhishek 3, that is A and C. Ravi 3, A and C. A and C, 3. Very good, A and 3, correct. Mr. Satyam, not 2. Both. He can be, see, the inquiry authority should be either senior or equal. He cannot be a subordinate. Remember, Satyam? It is only 2 categories. Either he can be of equal rank or he can be of senior rank. Need not be from outside. That is not intended. So only senior or equal. A and C, 3. Okay, next. Disciplinary inquiry against an employee shall be conducted only by
A and B both.
pardon. A, 4, C and D. Tell me. Very good. It is a D. Yoshna, you are confused. Disciplinary inquiry can be against an employee shall be conducted only by the disciplinary authority or what is known as either A or B, inquiry authority. Disciplinary authority can himself can be the inquiry authority. Inquiry authority can be separate. So the choice here is he can be a disciplinary authority or he can be an inquiry authority. A or B is the answer. Either
So
A or
so
B. D.
so I,
D is
I
the
I have a question, sir, in that case.
yes, tell me.
So in that case, in some of the case, that means that whosoever be the inquiry authority, and
No.
he framed the
Satyam,
charges.
be clear. I'm not able to hear you properly. What is that?
Okay, sir. Sir, is my voice audible now, sir?
Yes, tell me.
Sir, so my question is, so in that case, if the answer is either A or B, so in that case, inquiry authority frame the charges, and to whom it will submit the for the quantum of penalty. Then in that case, it
One
will be
second.
submitted to the
Very good
disciplinary
question.
authority.
I will tell you. Very good question. See, disciplinary authority, first he will issue the charge sheet. Charge sheet, he get the written statement of the defense. Now, there are two options left to the disciplinary authority. Number one, he can himself inquire into the case. He can himself inquire into the case. Alternatively, because disciplinary authority, by virtue of his position, he has got a number of work. So disciplinary authority, he can appoint an inquiry authority. That inquiry authority will inquire. So here the question is, the disciplinary authority inquiry against an employee shall be conducted only by the disciplinary authority, inquiry authority, presenting officer out of question. The possibility is either disciplinary authority or inquiry authority, who is appointed by the disciplinary authority. That is the intention. Remember, it is not normally the disciplinary authority will not himself conduct the inquiry because it is
Yes.
Attributed tomorrow. He will become the witness. Such work will be entrusted to the third person. That is the normal, what is known as jurisprudence principle. So that is, see, for instance, even in the our criminal branch, investigation and trial should not be with the same person.
Yes.
Police investigates, and trial is also he is to conduct the trial. It is wrong. Investigation should be different, and the court approaching the court should be different. That should not be the case. So that is already there. It is not very hectic task, but this is the intention. Next, a charged officer required to submit the reply to the charge sheet.
See.
$15 days. Mr. Ravi, it is 15 days, not 10 days. How 10 days have crept in, I know. Because in CCA rules, if you see the model form, that is the end of CCA rule, there is a Rule 16 charge sheet. In that, they have mentioned as 10 days. No. It is 15 days. The charge sheet reply should be statutory reply 15 days, 15 days, 15 days. Total 45 days. So remember, it is very important MCQ. Next. Question 5. Penalty of compulsory retirement, removal or dismissal from service shall be imposed by immediate superior, appointing authority, disciplinary authority, any of the above. Now, again, it is a straight, you are not understood the question properly. Compulsory retirement, removal, dismissal. These three are major penalties. Disciplinary authority, I told you, disciplinary authority is a vague term. It is not a clear term. Kindly understand, because unless you work in the vigilance branch or in the administration, this point you may not be able to appreciate. Disciplinary authority, suppose let us say a Group D official. For him, the disciplinary authority may be under secretary. His appointing authority may be director. That is, the under secretary can issue only 1 to 4. His penalty is 1 to 4. Appointing authority director has full powers, up to dismissal he can impose. If you choose what is known as disciplinary authority, it gives an impression that disciplinary authority may be competent only for minor. Then how he can impose a dismissal, removal, or compulsory retirement? So the choice is appointing authority. Appointing authority, irrespective of the status, he is competent to impose all minor penalties. Whereas the disciplinary authority may or may not. That is why I told you in the first class, all disciplinary authorities are not appointing authorities. But all appointing authorities are disciplinary authority. Kindly, it is very, I agree, it is a point is very, very nuanced in the sense let us say of a secretary is competent to impose major penalty. So you can call the what is known as the under director as a disciplinary authority, because he is competent to impose only censure. He is a disciplinary authority. Secretary is appointing authority. Why? Secretary impose all the penalties. So don't confuse with appointing authority and disciplinary authority. The moment there is a term called compulsory retirement, removal or dismissal, always remember appointing authority, because he enjoys concurrent powers. He enjoys concurrent powers. That is the, now let us say in the constitution, a high court has jurisdiction only up to the state, whereas Supreme Court has the jurisdiction entire country. So similarly, the appointing authority has a wider jurisdiction. Disciplinary authority has lesser jurisdiction. The same thing you should keep in mind here. Next. Appointing authority. B. Abhishek. Very good. 3. 3 is the answer. 6, 3. A. Then 7. D. Easy question. Very good. Very good. Next. Accused employee may appoint a legal practitioner. Next. Question 8. Yes, except Abhishek. Tell me, quick. Tell me, Satyam.
I'm not sure, sir.
Huh?
I'm not sure about the answer, sir.
Yes, Ravi. A and B. What is A and B? Ravi A. Inquiry authority. So permits. Presenting officer legal practice. A. Okay, Mr. Abhishek was correct. But let me explain. Accused employee may appoint a legal practitioner as his defense counsel for circumstances mentioned. If the presenting officer is a legal practitioner, yes, there is no doubt in it. The accused government servant automatically gets the powers, gets the discretion to appoint a legal practitioner because presenting officer legal practitioner. If the inquiry authority so permits, inquiry authority has no powers to allow the accused government servant to engage a legal practice. He has no powers. Who has the powers? Disciplinary authority. So disciplinary authority can, having regard to the circumstances of the case, disciplinary authority can allow the charged official to engage a legal practitioner. So remember, A and C is the correct answer. D. Next. Yes. Tell me 9. Yes, Jyoshna, why you are silent today? Very good. A. There is no doubt in it. A. Next. It is necessary to hold an inquiry before imposing a major penalty. Before imposing a penalty of withholding of increment adversely affecting amount of pension, period of more than 3 years, cumulative fact. If the disciplinary authority considers it necessary before the premature retirement of the FRBTC J. What is the answer? Vishek C. Yes, tell me, kick. Yes, tell me, D. Sorry, you should know. Yesterday, I remember I told you, but you might have not have concentrated. Premature increment, it is a premature increment. Premature retirement is not a penalty. So there is no need for major penalty proceedings for this. Very, very important. I have given you the notes also. I'm sorry you have not even read the notes once. What will not amount a penalty? Kindly go through. What will not amount a penalty is FR56 J or Rule 42 of CC Pension Rules 2021, where a person, a government servant, can be unceremoniously sent out without any inquiry. Suppose, God forbid, 50 years age for Group A and B, 55 years for Group C and D. Once it is crossed 50 years, Every quarter, the name will be put up before the committee, and the committee can review and give you a notice of 3 months salary or 3 months notice. No explanation, no reason to be cited. The order will be 1.5 line. You are prematurely retired and refer this J in public interest. Failure to provide the property returns, evasive returns, not necessary that your CR should be 5 years. From the date of entry, you might have put on 35 years of service. From the date of entry into the date of review, any record can be checked. Any report can be checked. Any if it is any perfunctory. Suppose if you are not given the property return, and if there is any indication of doubtful integrity, that even anything, remember. And remember, another most important thing you should remember is, this review is not once review is done, I am 50 years. Okay, review is done. Am I safe up to 60? No. Every quarter it can be renewed. Every quarter, next quarter I can be reviewed. Next quarter I can be reviewed. It is the domicile sword hanging on your head. Any time it may fall. But 50 years to 60 years, 1 year they will not do it. 1 year before the normal superannuation, they will not. Otherwise, even if there is a property, even your doubtful transaction, if you have not given the property returns, even if you have not given the property returns, it is good and sufficient reason, because there is no need for calling for explanation. The order will be only public interest. 363 Group B and Group A officers have been retired during the past 3 years. Remember, very, very important. There is no need for any inquiry. Yesterday I told you, compulsory retire. It's very important. Academically important, exam also important. So, that of course we will see when we take a pension. Very, very important point. Academically also, it is not you cannot be indifferent to the reality. So what are the, and remember, the sadder part is the Supreme Court has upheld all the decisions of the government. All the decisions of the government. Just imagine, 50 years for Group A and B, 55 years for Group C and D. 50 years to 60 years. 10 years service. You are given full pay and pension, full pension. Leave and cash, gratuity, commutation, everything is allowed. But remember, the point you should remember is, there is, suppose let us say you have gone some study report. You are not given study report. Or your preparation of notice proper, not proper. The committee can take this into account, because it is not necessary to reveal to you. Not necessary. It is the prerogative of the committee. If the committee says, no, this work is like that, totally inefficiency, that's all. It is inefficient. So remember, it is the discretion of the committee. It is a committee means joint secretary and above. Joint secretary and above are the most, whether it's an ad hoc appointment, they can terminate. Premature retirement, they can terminate. Officiating, they can terminate. Cutting the deputation, they can do it. They can revert you without, it will not amount a penalty. All the powers are concentrated with the highly placed people. Okay. So we'll end the answer. Sorry, ABC. Okay, we will end tomorrow. Next class I will let you. You should send the messages to me. What is the problem? This is what I wanted to finish 2 or 3 things, but time is constrained. I will tell. Thank you. Thank you.
Thank you. Thank you, sir.
Thank you.
Thank you, sir.